Welcome to Frank Bruno Law. I am Frank Bruno. I'm an elder law and estate planning attorney in New York. Today I conducted a will intake. I spoke with a person over the phone concerning the preparation of a last will. In that consultation, a question was posed to me, and I'm going to relay that question to you, the viewing public, as a public service. Before I get to that, if you have a question of your own, if you'd like to speak with me about any elder law issue, please go to my website, frankbrunolaw.com. So the question that I fielded, and there was a number of questions, but the one that I'd like to share today is, what are the grounds to contest a will? So I'll give a few. And this is not an exhaustive list, but as part of the conversation, I gave some examples. So if the will is not correctly prepared, that would be a reason. If it was incomplete or faulty in some way. So a will has legal requirements, right? You need 2 witnesses. In New York State, you need 2 witnesses. So if you only had 1 witness, that would be an incomplete or faulty will. If the person never signed it, that would also be incomplete. Say the will was prepared, but we never got around to signing it, executing that will. So that's at least one reason. Lack of capacity, meaning that the testator, the person that's preparing the will, not the lawyer is preparing the will, but the person that has issued the request to prepare a will, that person needs legal capacity. They need to know their bounty, who their children are, what their assets are. They have to have legal capacity to enter into an arrangement. A will would be, it's not a direct parallel, but a will would be like a contract. So you need to have the capacity to enter into that contract. The standard is different, but it's a good example for this conversation. There cannot have been undue influence. And it's extreme, but there could not have been someone that was influencing you to make the will or bequest in a certain way. Gun to the head, so to speak, extreme pressure, that would be undue influence. That would be another ground to contest a will. Fraud. Fraud would be the person was signing a document that didn't have their desired information in it. So if I prepared a will, but it did not have the people that, I started inserting Frank Bruno into the document. Everything to Frank Bruno, and Frank Bruno becomes the executor, and that would be fraudulent. Unless the person wanted to have me throughout the document. But even then, that would raise red flags about their mental capacity. So that wouldn't fly. If you have any questions for me, please send them by email to frank@frankbrunolaw. Thank you.